go. Do you want
Okay.
me to let Mr. Thompson or Miss Thompson in?
We had him there and he disappeared.
Huh. There we go.
Oh, this is the name change right there.
Okay. Right.
That's not till 2 o'clock.
Oh, okay. I guess I'll wait to tell her. But
Okay.
nobody's at 1:30, so
Ms. Thompson, we have a 1:30 hearing. Before I do the name change, and you're not coming through either on mic.
Can you hear me now?
Yes. Have you sent me a proposed order?
Yes, sir. You should have all that. It was brought in yesterday.
Brought in?
Yes, sir.
Okay, I'll have to track it down because I've not received anything in actual physical paper. Everything has been uploaded. Now I will look and see if they uploaded it.
Okay.
can I get the spelling of your first name, the one that the case is filed in?
Charles, Charles.
Okay, and then what's the new name?
Chelsea, Chelsey.
Awesome, thank you.
You're welcome.
They did send me a proposal, or they've scanned in and uploaded what you brought in. Okay. We're gonna have to take care of this 1:30 hearing, so we're gonna put you back in the waiting room probably. But first, before we do that, where are they? I can't believe this. They've sent me over 800 pages about this hearing, so I know they're coming. Court is going to be in recess for a moment.
Yes, sir.
Yes, sir.
All right, 95th District Court is back in session. Ms. Rouse, let's go on the record. The council on the motion for summary judgment were on a different Zoom meeting ID, both waiting for us. So they're going to call into this in just a second. We'll admit them unless Ms. Thompson doesn't want us to.
You're fine.
As they come in, but we're going to proceed with the name change, the 2 o'clock name change. This is in the matter of the change of name of Charles Dwayne, Dewayne Thompson, THOMPSON, cause number DC 20-08503. Ms. Thompson, I have to advise you that pursuant to the open courts provisions of the state of Texas Constitution, this proceeding is being conducted remotely, but is available to the public through the court's YouTube channel. Therefore, it is broadcasting live as we speak.
Okay.
That said, no idea if anyone's watching, because all the courts are doing this. There is a procedure that has to be followed, however, and one of those nuances is any recording of this proceeding is expressly prohibited, because I have not given an order allowing recording of this proceeding or of any proceedings this afternoon. You cannot copy this proceeding. There's one record only that comes out of this proceeding, and that is the record that's maintained by Ms. Rouse, the official court reporter of the 95th District Court. Do you understand that?
Yes, sir.
All right. I'm also, because we're doing this remotely, we're going to take your oath over the internet. That's normally not possible, but the Supreme Court of Texas has authorized that during the COVID emergency. The oath that you're about to give carries the same weight and consideration, and therefore it is subject to perjury laws, just the same as if you were standing right here in the courtroom and I were administering the oath to you, where we could see each other face to face a few feet apart from each other. Do you understand that?
Yes, sir.
All right. Would you raise your right hand?
Let's start right.
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
It is my understanding that you wish to have a change of your name.
Mm-hmm.
Oh, you can let your hand down.
Okay.
You wish to change your name and also have a gender marker correction.
Yes.
Is that your understanding of what you're trying to do today?
Yes, sir.
Now, I understand, and we're going to have testimony on this in just a minute. Understand that your driver's license is issued by the state of Mississippi. Is that accurate?
Yes, sir.
You know, I have no authority whatsoever over the state government of Mississippi. I can no more order the state of Mississippi to make any sort of gender marker change on anything than I simply have no authority to do that. Do you understand that?
Yes, sir, I did.
All right. If you were to apply for a Texas driver's license or Texas identification card, what we're doing today potentially has effect on that. Do you understand that?
Yes, sir.
All right. You have been placed under oath, and let me ask, is your full name Charles Dwayne Thompson?
Yes, sir.
Were you born on March 11, 1979 in Tupelo, Mississippi?
Yes, sir.
You currently live on Melody Lane in Dallas County, Texas.
Yes, sir.
Are the last four digits of your social security number 0209?
Yes, sir.
You have a driver's license that's been issued by the state of Mississippi. Is that correct?
Yes, sir.
Is that driver's license, or does that driver's license bear the last four digits of 8528?
Yes, sir.
Let's go on recess for just a second. My court administrator has something to tell me.
Yeah, she called me too.
Okay, we're back on the record. In DC 20-08503, she was just telling me that the council in the other hearing are calling in. All right. At birth, your gender designation was male. Is that correct?
Yes, sir.
All right. Your race is black, correct?
Yes, sir.
Do you have, or well, it's my understanding that you have a state identification or FBI number, correct?
Correct.
You have filed with this court a criminal history record. Do you understand you have done so?
Yes, sir.
All right, the court will take notice of the criminal history record that you have filed. It shows a charge arising out of Collin County from an offense allegedly occurring in 2009, but for which there was no proceedings. The charges were dropped. Do you know the alleged offense that I'm referring to?
I'm not sure. I can't remember where Collin County was. It may have been a speeding ticket. I haven't gotten anything other than speeding tickets.
Well, actually, it's got an unauthorized use of a vehicle.
Unauthorized use? Oh, okay. Yes, I know of that one.
All right, and did anything come of that charge?
It was dropped because the person that they were trying to reach to find out was it their vehicle was unreachable at the time, but they were able to get through to them.
All right. Do you have any other than strike that, other than traffic tickets, do you have any other criminal history at all?
No, sir, none whatsoever.
And so this criminal history that you have filed with the court is accurate?
Yes, sir.
You have also filed with the court a letter from Nuri Marquez, licensed social worker, licensed master level social worker. Are you aware of that filing?
Yes, sir.
Did you cause it to be filed?
Yes, sir.
Did you ask that Ms. Marquez file that letter?
Yes, sir.
All right. Are you asking the court to rely on that letter?
Yes, sir.
All right. The court takes notice of the August 2020 letter authored by Nuri, N-U-R-Y Marquez, which was filed with the court on August 27, 2020 for all purposes. So going back to your criminal history, you have not had a final conviction of any felony in this state or in any other state, correct?
No, correct.
All right. You are not required to register as a sex offender under Chapter 62 of the Code of Criminal Procedure, are you?
No, sir.
All right. Did you provide a legible and complete set of fingerprints to the Texas Department of Public Safety for them to produce this criminal history report to the court?
Yes, sir, I did.
All right. Are you requesting that your name be changed from Charles, C-H-A-R-L-E-S, Thompson, T-H-O-M-P-S-O-M, to Chelsea, C-H-E-L-S-E-Y, Long, L-O-N-G?
Yes, sir.
And I correctly spelled the name that you wish to change your name to?
Yes, sir, you did.
Are you also requesting that a gender marker correction be made to now identify yourself as female?
Yes, sir.
Have you completed or have you undertaken the necessary treatment for gender transition?
Yes, sir.
Are you seeking to change your name for purpose of evasion of any debt or any obligation to the state or any of the states of the United States?
No, sir.
Let me print one thing here real quickly.
All right.
Okay, Ms. Thompson or Ms. Long, I have before me your proposed final order granting change of name of adult with gender marker correction. Court will order that your name be changed from Charles Thompson to Chelsea Long. Court will order that the corresponding gender marker be corrected from male to female. The court will order that the Texas Department of Public Safety issue upon your application, if you wish to file for an application, a driver's license or identification card with a corrected gender or sex marker change from male to female. The court will order that all public and private agencies within this court's jurisdiction, which basically means within the state of Texas, not anywhere else, correct their records to reflect that your name be changed from Chelsea or to Chelsea Long and the gender marker be corrected to female. Court will order that any state agency correct your name to that name Chelsea Long, and that your gender be reflected as female. I'm including in the order that the Texas Department of State Health Services Vital Statistics Unit can issue to you an amended birth certificate, but it's my understanding your birth certificate was not issued in the state of Texas in the first place, was it?
Correct.
All right.
It was Mississippi.
All right. And I'm ordering that you not use this name change or the change of your gender identification for the purpose of avoiding any or all past or future financial or credit obligations or liabilities, or for purposes of fraud, or for circumventing any laws or ordinances of any jurisdiction. Do you understand that obligation on your part?
Yes, sir. I understand.
All right. With that said, I am signing your order effective today, August 28, 2020. And unless you have anything further before the court, you're excused. You can get a copy of the order, but it'll probably be Monday or Tuesday before you can really get a copy from the clerk.
All right. And I greatly thank you.
My pleasure. You have a wonderful day and a good weekend.
You too, Your Honor.
Thank you.
Thank you.
Bye-bye.
Bye.
that was the name change. Now where are they?
I have to put them in.
Oh, all right. Oh, you're host, so that's why you're seeing them.
I don't know what happened with that. I forwarded it to Karen. I don't know.
Good afternoon.
Good afternoon. Give me a moment to sign some paperwork from the one we just did. Supposed to be at 2:00. So now we've done it while y'all were off in the digital desert there, I guess. The good news is that gives you basically the afternoon, except we're not going to take the afternoon.
Miss Schwartz, what's your first name?
Susan, S-U-S-A-N.
Thank you.
Okay, are we ready on Prospect Custom Homes versus Gregory Michael Scorza?
Yes, Your Honor.
Yes,
This is cause number DC 19-18703. Prospect Custom Homes LLC versus Gregory Michael Scorza and Greg Scorza Appraisal. And counsel, I've got something I have to go over with you on the record. This proceeding is being conducted remotely, obviously. It is being conducted in accordance with the open courts provisions of the state of Texas, however, meaning the court is open. In fact, bailiff just went and made sure the doors to the courthouse or courtroom were open. It is open to the public. There are no members of the public present. But we're also, to make sure that it is available to the public, we are broadcasting this proceeding on the court's YouTube channel. If you have an interest, the Office of Court Administration of the state of Texas maintains a list that's updated, it's refreshed constantly, of every court that is broadcasting live on YouTube and with a link to that court's YouTube channel. So you can, if you have an interest in finding out if the 96th District Court in Tarrant County is running live at any given moment, you can find that and watch. And I'm just sharing that for your benefit. The reality is that creates certain difficulties. Recording of proceedings in the court, absent an order of the court, are not permitted. And I have to advise you that you are prohibited, parties are prohibited, and the public is prohibited from recording off our live stream or copying that live stream for recording purposes these proceedings. There is one record and one record only that comes out of this court, and that is the record maintained by the official court reporter of the 95th District Court, Ms. Rouse. Any questions about that?
no.
Let us then proceed with introductions. Ms. Schwartz, would please identify yourself and whom you represent.
Your Honor, my name is Susan Schwartz with Wilson Elster. I represent Gregory Michael Scorza and Scorza Appraisals.
And Mr. Hutchison, please identify yourself and who you represent.
Your Honor, my name's Steve Hutchinson. I represent Prospect Custom Homes LLC.
Okay. This is a motion for summary judgment, correct?
Yes, Your Honor.
And Ms. Schwartz, it's your client's motion, correct?
Yes, Your Honor.
All right. Before we begin, I'm going to chastise the two of you a little bit here. This is a motion for summary judgment on what appears, and I've read what you have filed. I've read in fact, more than once read the motion and the amended response. There's been 2 responses and the objection reply. Everything that was filed almost is filed in violation of the local rules. And then on top of it, I got a 302-page courtesy binder yesterday. How many trees are we going to kill on a pretty simple motion for summary judgment? I mean, I could, but I'm not going to strike everything that was filed on this. I've got a 128-page motion followed by a 400-page response, followed by a 74-page amended response. I mean, all of that's in violation of our page limitations. And let me see if I can boil this down. As I understand the motion and what we're fighting about here today, the argument is whether or not Gregory Michael Scorza and Greg Scorza Appraisal has a legal duty, either in contract or in tort, to Prospect Custom Homes LLC. Is there anything more to this proceeding than that?
No, Your Honor, other than there are additional causes of action which we believe are implicated, such as the exception to the deceptive trade practices. But you are correct. Duty is the fundamental issue.
Mr. Hutchison?
I would agree that's the main issue, yes.
Okay. All right. As a preliminary matter, there are objections to that were filed by Mr. Scorza or by Ms. Schwartz,
Right.
to some of the summary judgment evidence filed by plaintiff. Might as well be correct on the record about this. The objections are as to exhibits 1B through 1F of the response, and as to the mains, MANES declaration. Were there any more objections besides those objections? I know there's multiple objections to them, but were they all confined to those?
No, Your Honor, there was another objection filed after Mr. Hutchison filed his amended response last Friday, which attached a business records affidavit containing the TALCP records.
Sorry, can you say that again? You're really hard to hear. Can you say the acronym again?
Rouse, let me do this. Yesterday I was in a Zoom presentation and there was something wrong with my audio, even though it seemed to work. May I, Your Honor, get the phone number and I'll call into the court?
It's perfectly fine with me. I don't care how that proceeding is done.
Well, my concern is if Ms. Rouse can't hear me, then she's going to have a difficulty taking down what I say.
I can hear most of it. I just don't want to have to keep interrupting.
Well, I'll do my best to speak up, in Your Honor.
That's excellent.
Okay.
When you moved up, it was like the mic picked up 50% more.
All right, very good. Then I'll get very close and see if we can get this done. We filed on August 25th, we filed another objection to the TALCB record that was attached to the amended response to Mr. Hutchins.
Okay.
To our motion.
Now, that might have cured some of the other objections, but it's the same body of evidence, correct?
It is. So it is the
Mr. Hutchison, are you of the understanding that the objections go to the same sets of evidence, the exhibits 1B through
F, I believe.
1F, and the Maine's declaration with the subsequent filing simply being a correction or an attempt to correct the hearsay problems or potential problems with the TALC records?
Correct, with a business record affidavit from their custodian. Yes,
All right.
yes.
Here's my question. Do the objections make a hill of beans a difference? Do those exhibits make a hill of beans a difference on the legal issue of whether or not there's any duty owed?
No, Your Honor, they do not.
Mr. Hutchison, do you agree?
No, I don't think so, Judge. I think particularly the investigative report from the TLCB is kind of explains what the issues are.
Well, I understand that if we try this case, y'all are going to fight whether or not any of that comes in evidence, because obviously, Mr. Hutchison, you're going to want that evidence heard, and Ms. Schwartz is probably not going to want that evidence heard in a persuasive setting. But what I'm asking is, do those exhibits make any difference on the legal duty of what, or the legal issue of whether or not a duty is owed by Mr. Scorza or his company to plaintiff?
Judge, probably not, other than to the extent that they set out what the standards are for the TALCB. They reference USPAP and
but again, that goes to the fact that goes to the factual issue of whether or not, I mean, perhaps goes to the factual issue of whether or not he was negligent or not. But does it? I'm sorry, counsel. I'm fixed unless you all dissuade me from this, that this entirely is a fight about whether or not there is a legal duty owed by Mr. Scorza or his appraisal company to Prospect.
Yes, Judge, that's a linchpin issue.
All right. If y'all haven't, I think I figured this out, so I'm going to go at this backwards. If you don't mind, I don't need y'all to lay out the entire situation. I really don't need that. What I'd like to hear, mostly from Mr. Hutchison, is why and under what legal theory there is a duty owed by Mr. Scorza and Gregor Scorza Appraisal to Prospect Custom Homes LLC. And I know, or I'm just guessing, based on the plea, on what you've written, that you're going to cite me to the Dallas Court of Appeals case. Oh, and the name has all of a sudden escaped me. Is it Cook?
Cook, yes. Yes, the Cook case with the surveyor.
Persuade me that applies to this case, Mr. Hutchison, if you can.
Judge, the factual situation is very similar. You've got a professional that's providing a service as part of a sale transaction. In that case, it was a surveyor. In our case, it was an appraiser. And there were clear problems, errors, or let's assume for discussion, there's clear errors in the service provided by the surveyor. Here we have an appraisal that had numerous mistakes that created a problem in the appraisal. And in the Cook court, the court concluded that the subsequent purchaser was reasonably foreseeable that subsequent purchaser would be damaged by that by that surveyor's mistakes that occurred earlier on, and there was no requirement in that case for a contract between the two. And the court extended a negligence type duty to a subsequent purchaser that the surveyor certainly could foresee that the property was going to be sold again, and if there were problems in the survey, it could cause a problem down the road. This case is a lot closer because it's a seller in the transaction, same transaction that the appraisal was requested and submitted. And there were significant problems with the appraisal. And, our view of Cook is that it's very similar and extends a duty to that seller in this case.
Okay, Ms. Schwartz, is Cook still good law?
Your Honor, I don't believe the Cook case is useful for these purposes.
That's not what I asked. Is it still good law?
I think it's still good law, Your Honor.
All right.
Not
So
anything.
therefore, ostensibly, it's binding on this court if it applies.
Yes.
Tell me why it doesn't apply.
I think the factors that the court looked at in Cook are very different. I think there's a very extraordinary distinction between a surveyor and an appraiser for purposes of allowing duty. In the survey case in Cook, the court, in looking at what was the basis for it undertaking or allowing the duty, was it looked at the survey itself. And the survey itself stated, to all parties interested in the premises surveyed. That was on the face of the survey, as well as a warranty stating that the meets and bounds and the boundary lines were appropriate and set. The difference between a survey and appraisal is extraordinary, because a survey, you would think, hopefully, two surveys of the same piece of property ought to come up with the exact same meets and bounds. It is not the type of situation where an appraiser gets to go and pull different comps. The property values will change over time, so an appraisal could be very different as opposed to a survey. The plot of land should not move just unless there's something extraordinary like Laura, the hurricane, just came through and apparently took land. So, but in this situation, we do not think Cook is appropriate. And also, the concern is if a seller has the ability to go after the appraiser who was hired by the bank and whose appraisal document in and of itself says this is not applicable to you, the document itself, the appraisal itself, which is considered A3 to our motion, states in many different places the purpose and the intent and the intended user was the lender client, which was Iberia
I'm
Bank.
sorry, cut out. The purpose and intent, can you say that part again?
Purpose and intent of the appraisal, and what is on the appraisal many places is that it is the intended user is the lender client, which in this case was Iberia Bank. And there are in the appraisal itself and the paragraphs associated with the appraiser's representations, one of the thing is there are certain persons who are able to get the appraisal and have it in their possession, including the mortgager, mortgage companies, the buyer, the U.S. government, but nowhere in that laundry list in that paragraph is a seller. And so the intent of the appraisal document in and of itself states that a seller is not an intended beneficiary or an intended user of the appraisal. So
here's how I see this. On the straight duty standpoint, Cook involved a linear line of duty, for lack of a. You've got people who are subsequent in the chain of title directly down, and the question is, does the surveyor up here still owe duties through the rest of the chain of title. And that's a different standpoint than here where we got two people on opposite ends. It'd be one thing if Prospect, instead of being the seller and a buyer, if Prospect were a subsequent, an assignee, a bank buying this portfolio of loans from Iberia, or possibly a later seller, although that's a stretch, but or later buyer, I mean, down this same chain. They're over here. Mr. Hutchison, here was what I kept thinking. If I've got lawyer A and lawyer B duking it out in litigation, and the client of lawyer B says lawyer A was negligent in that in his representation of his client, and it cost me damages because the litigation went on longer or whatever. Does the client of lawyer B, in fact, have a cause of action against lawyer A?
I don't think so, Judge. And I'd like to, if I could address factually an issue that I think is part of what we're talking about.
Okay, and I'll give you that point, but here, the fact is, all the claimants in the Cook case are in the same line of title, aren't they? As opposed to opposite ends of this transaction.
In Cook, yes, in Cook,
All right.
it's the same piece of property. To us, to me, this is a closer situation because it's the same loan transaction that the appraisal was created to support.
Same piece of litigation that lawyers A and B were
Right.
were duking it out about. Okay, continue. You said you wanted to draw a distinction.
In the example of the lawyer situation, I don't think that either lawyer has any expectation that what they're doing is for the benefit of the other client. And in factually in this situation, if you go to the motion for summary judgment that was filed, and you go look at the appraisal report, it's Exhibit A3. If you go to the end of the report, there's a section there that says appraisal and report identification, and it's a choice that the appraiser has to pick what type of appraisal they're going to send out. And it says this report is one of the following types. The first type is appraisal report, a written report prepared under Standards Rule 2-2A pursuant to the scope of work as disclosed elsewhere in this report. The second, and that's the choice that was chosen by the appraiser, Mr. Scorza. The second choice is restricted appraisal report, a written report prepared under Standard Rule 2-2B pursuant to the scope of work as disclosed elsewhere in this report, restricted to the stated intended use by the specified client or intended user. So the appraiser has a choice on this appraisal to whether it's a restricted appraisal or whether it's an appraisal that is unrestricted, whether it's restricted just to the client intended user or whether it is not. And the appraiser chose that it is not restricted. So that, our perspective is there's a more of an understanding expectation that there's others out there that are going to be impacted by this appraisal.
And yeah, there may be others impacted, but that still doesn't give me the duty. We're going back to Paul's graph in law school here. I mean,
Right, right.
And I have no objection. That's where the law gets interesting.
Right. Yes.
I don't see where, let me make sure. Prospect was the home builder, correct?
Correct.
And they had a home buyer that they were trying to sell it to.
Correct.
And that home buyer went to Iberia to get a note
Correct.
or to get their loan.
Get it financed.
And
Yes.
it was Iberia that hired Mr. Scorza to make sure that the loan that they were given was supported by an appraisal, correct?
That's correct. That's correct.
I just don't see how there is a tort or a negligence duty owed by Mr. Scorza to the home builder. And then we get to the issue of the damages, and I understand the economic loss rule and y'all's fighting about the economic loss rule.
Right.
The reality is Prospect willingly reduced the price of their sale to the amount of Mr. Scorza's appraisal so that Iberia would lend it to the prospective buyer, correct?
They reduced the price, not all the way down, Judge, but yes, they reduced the price as a result, and went ahead and made the deal and closed the sale. That is correct.
All right. Anything further?
The only other thing I would add, Judge, is I have not found a case in Texas that's answering this question clearly.
Fair enough.
I agree with that as well, Your Honor. When I look at the issue, though, I put Mr. Scorza in the same position as I'm sorry, Judge. Put Mr. Scorza in the same position as an inspector who inspects the house for a buyer. And again, would the seller be able to say, oh, they've said it had foundation problems when it doesn't, and then they sue as well? So it's a very significant problem and a challenge to expand that duty this way.
Okay, here's what the court's going to do. I'm going to deny all of the objections to the summary judgment evidence, but I'm going to grant summary judgment to Mr. Scorza and Greg Scorza appraisal. And I'll be blunt. Here's why I'm denying the objections. I don't want this. If the Court of Appeals is going to reverse me on it, I want it to be reversed, not on the evidentiary, and send it back to me, right, saying you should have considered this evidence.
Right.
I mean, I'm not really rendering any opinion about the objections, the admissibility, anything else, but I don't think it impacts this decision. So I'm not going to run that risk.
Okay.
Your Honor, I believe we have a proposed order that was sent to the court reporter.
I received a proposed order earlier today.
That may have been Mr. Hutchinson's denial. I think when we filed our...
Oh, that is correct.
I think when we filed our motion several months ago, we sent a proposed order.
I will tell you.
But I'm happy to get one and submit it to the court this afternoon.
Well, I may want it in Word format anyways. I'm looking here. Oh, there's the proposed.
Judge, could I ask a question to clarify?
You may.
We had negligence claims, which the duty question we're talking about is central. We also had a third-party beneficiary claim that the duty is It's a separate kind of a claim.
Lesser being, I don't think he was a third party beneficiary as a matter of law. The misrepresentation on the DTPA, I don't see a DTPA case, and the gross negligence is handled by the duty. If I'm covering all of them in order, and I think I am.
Yeah,
I don't see it.
The two outliers were the third party beneficiary and the DTPA.
Yeah, I just don't see anything there. I mean, it's an interesting question. I also don't think that really there's a contract claim, but the negligence claim, that's interesting. And I think it's a matter of law. And I invite you all to duke it out at higher courts, but and argue your Paul's graph and your in your duty all day long. I didn't find anything else for what I didn't look hard, but I looked at Cook and I didn't see anything in Texas that directly answered it either. So, tell you what, Ms. Schwartz, what I've got are separate orders. Would you have either directly or have somebody submit orders in Word? And I may work on, I may add or subtract some stuff out of this, but send me a proposed orders in Word. Be sure to copy Mr. Hutchison when you do so. Send them to Ms. Alonzo, and she'll forward them to me.
Would you like a consolidated, just one order, Your Honor?
I would prefer one order.
Very good.
All right.
Give it to you this afternoon.
Very good. Well, thank you both. Thank you. I know I gave you grief about the page. You got to be careful on the page limitations here.
I meant to apologize. I'm very sorry, Your Honor, for that.
I'm new to the bench, obviously. I've been here a month, and well, actually, I was sworn in 4 weeks ago yesterday.
Right.
Had my first judges meeting yesterday, and the local rule that they passed before I was appointed, that I've now adopted on the page limitation, actually came up, and we did this meeting by Zoom, and I held up this from another hearing
Oh, dear.
that was delivered to me yesterday, and one of my fellow judges held up this. and so I tell you that, meaning that there are some judges who this wouldn't have gotten to first base. That is exactly and it all depends on the individual judge. Be careful on these page limits. We are killing way too many trees and causing way too much to have to be read over. I mean, if you need more pages, file a motion for leave and show why. But I gave you my grief on it. I still considered it all. So.
Okay.
All right. Thank you.
Mm-hmm.
My pleasure.
Yeah.
Bye-bye.
Have a good day.
Bye.
You're excused.
Okay. Thank you.